Levante Shannon.
Yes, sir. Can you hear me?
Alexander on behalf of the people.
The moment this hearing begins, you can already feel the tension. We're looking at Levante Shannon facing his third OWI that's operating while intoxicated, with a staggering blood alcohol content of 0.188. For context, that's more than twice the legal limit. His defense is walking a tightrope today, trying to convince the court he deserves another chance after repeated violations. But here's where it gets messy. Shannon's argument revolves around something most people wouldn't even think twice about: non-alcoholic beer. What starts as a misunderstanding quickly turns into a courtroom storm, and Judge Simpson isn't buying the excuses. This isn't just about one man's relapse. It's about accountability, honesty, and how a single harmless drink can derail someone already on thin ice. Watch closely. Every word, every reaction, and every slip of the tongue matters in this hearing.
Can you hear me? Can everybody hear me?
Assistant
Yes.
Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, will you state your name for the record?
Levante Shannon, Levante Cedric Shannon.
Okay. What are we doing today?
Your Honor, today's date and time, we are asking for an adjournment. Mr. Shannon has completed an inpatient treatment recently, so I'm asking for documentation from him so that we can further discuss negotiation with the prosecutor's office.
And Your Honor, before we start today, I did want to make the court aware that he's had multiple missed tests as well as positive tests from August 12th until September 10th, which is very concerning to the people given that this is an OWI third in which the BAC was 0.188 and he's had numerous previous OWIs.
And also, just so that you know, he's probably going to repeat what he put in the chat, which he probably shouldn't have put in the chat.
I saw that, Your Honor.
Yeah.
Can I say one thing?
I saw the distress on your face.
Yeah,
Mr. Shannon?
I had no idea because the scrambler, it was non-alcoholic beer. That's what it said, non-alcoholic. So I'm on naltrexone. I can't, this right here is a blocker. You can't get drunk on it. So I was just drinking for the taste of beer. We were barbecuing.
And there it is. Shannon drops his defense bombshell. He thought non-alcoholic beer was fine. Here's the problem. Non-alcoholic doesn't mean zero alcohol. Brands like DOUL's or Heineken 0.0 can still contain up to 0.5% ABV, enough to trigger scram or tether systems. His claim that it's just for the taste sounds innocent, but legally, ignorance isn't an excuse, especially when your bond terms clearly forbid any alcohol. Judge Simpson's facial tension says it all. Disbelief mixed with disappointment. You can almost hear the internal eye roll. This is where courtroom reality hits. Every innocent mistake is still a breach when you're under court supervision. Would you believe him if you were the judge?
And things like of that nature. And I was just only drinking.
Your Honor,
you might want to jump in here, Miss Apple.
Yes, Your Honor. So the information that Mr. Shannon did put in the chat, Your Honor, I would ask for some consideration considering this confusion on it. Mr. Shannon.
Confusion on what?
I didn't know that non-alcoholic beer contained alcohol because I was on the scrambler and it never came up.
Mr. Shannon.
Huh? Your Honor, it would be concerning as when he did test positive, he was at a 0.027, 0.021, 0.020, 0.016, and so on.
If the court would allow Mr. Shannon one final opportunity, he would report for a scram tether to prove to the court.
I threw it all out.
Your Honor, I request on behalf of my client one final opportunity now that it is very clear that he is not to consume even non-alcoholic beer as there may be alcohol in it and be placed on a scram tether. And that I can get the documentation regarding the treatment program. He did inform me that he completed a 30-day in treatment at Brighton Recovery Center and provide that to the court and to the prosecution.
Oh, I need a copy of the report because I don't have the report from community correction. This is one of those times that maybe if the client hadn't started talking, you'd get your wish, Miss Apple, but I don't think so. So what I'm going to do is I'm going to pass the matter. Can prosecutor or the public defender send to Miss Weidling a copy of his report, and then I'll call his case back up. We'll deal with this bond issue in the adjournment.
At this stage, Judge Simpson pauses the case to get more reports. That's not just bureaucracy, it's a subtle strategy. Judges often delay when they sense incomplete information or suspect a defendant isn't being fully honest. It's also a psychological move, giving the defendant time to stew in anxiety before facing the hammer again. This pause tells us the judge's patience is running thin. Miss Apple, the defense attorney, tries to regain control by requesting one final opportunity. That's defense code for he messed up, but please don't lock him up yet. The prosecutor's silence is loud here. She knows Shannon's digging his own hole. Watch for what happens next when Simpson reopens the case. It's about to turn from cautious to confrontational.
Understood.
Pass.
There you are. Please state your name.
Levotny Cedric Shannon.
I'm looking at this bond violation report, and my concern is I don't have a report before this one. I don't think. It's rained on 8/8. Yeah, because he was arraigned on 8/8. This is really the first violation report. And from August through net, well, because he didn't appear on August 17th. Well, we didn't get the report, but here's my problem with what I'm seeing here. On August 12th, after his arraignment, he gets to an 026. Then misses his scheduled retest on that August 12th day. We go 2 days later. Well, on August 14th, he blows a .066. Then it slowly goes down, so he then blows a 6.7, a 3.7, 0.37. And that's on the 14th. Then don't really have any incidents, although well, no, we do. Then on the 14th, he finally got down to an 0.4, but that actually went up on that day. Then that's on the 14th. Then we come down to September 8th, and he's missing other tests. But his makeup tests are showing negative. But then we get to September 8th. When he blows an 0.21, an 0.20, and a 0.16. Then on the 10th, he blows an 0.41, and then subsequent tests for alcohol thereafter showing that. And then later on the 10th, he missed a scheduled retest, but then later on the 10th, he's blowing numbers. Now, am I to understand that all of that is from Bud Zero?
This is the moment Shannon's credibility collapses. Judge Simpson's tone shifts from inquiry to disbelief. Bud Zero, O'Doul's, Heineken 0.0. Shannon's excuses are piling up faster than his test results. His attempt to sound technical, talking about naltrexone and scram technology, only makes it worse. You can sense the judge losing patience, especially after decades on the bench dealing with these same deflections. The subtext here is brutal. Simpson doesn't care about brand names or chemical details, he cares about honesty. This is the line between recovery and manipulation. And when the judge says, "You might want to think before answering me," that's courtroom language for you're about to incriminate yourself. If you were Shannon's attorney, would you have let him keep talking?
Is that the defendant? Hold it. Oh, whoa. And Mr. Shannon, let me just tell you, been doing this a long time. So you might want to think before you start answering me.
Okay.
Am I to understand that all of that's from Bud Zero?
Some of it's from O'Doul's, but Zero. I drink Heineken Zero, but I'm on naltrexone. So even if I was drinking alcoholic beverages, it wouldn't. You know what I mean? So it would defeat the purpose. I was just drinking because I'm around people that drink.
I didn't ask you all that.
Yeah. Well, yes, it is.
And you're saying it's from O'Doul's, Bud Zero, and what else?
And what O'Doul's, sometimes it's Heineken Zeros. I drink a ton of them. And I didn't know because when I was on the scrambler, it never appeared. It never showed dirty. It never showed dirty. It only shows dirty on this machine. This machine is super sensitive. I didn't know it. I didn't understand the technology.
Mr. Shannon,
Yes, sir. Yes, sir, Your Honor.
you blew an 06, a .06.
Yeah, and I looked it up on the website after I talked to my attorney, Miss Apple. I looked it up.
Okay, so Mr. Shannon,
Yeah.
I'm going to stop you right now because you already may have talked yourself into jail, but you're not helping yourself
Okay.
at all.
Okay.
But I'm going to give you an opportunity at least to speak with your client. I'm going to adjourn this matter to our 3:00 block with the bond hearings. I might suggest to you that between now and then that you get whatever affairs you need to get in order.
This is the courtroom equivalent of a warning shot. When a judge tells you to get your affairs in order, it's not advice. It's a countdown to jail. Shannon's still talking, still explaining, completely missing the point. Judge Simpson, on the other hand, is done listening. His line, "I hate when people lie to me," sums up the real issue, not the drinking, but the dishonesty. Judges can forgive relapse, but not deceit. Notice the body language here. Simpson leaning back, measured tone, eyes fixed. It's not anger, it's controlled authority. This is a man who's seen hundreds of defendants try to outtalk consequences, and every word Shannon adds digs him deeper. What do you think? Does Judge Simpson sound fair or fed up?
Okay.
The first thing you probably ought to get in order, and you can have that conversation with Ms. Apple, is you might want to get your story in order to me. I don't, I realize people mess up. I get
Yes,
it.
sir.
But the thing I hate more than that is when people lie to me.
I understand that.
I'm just going to leave it right there. We'll see you at 3:00.
Clarify, is that in person at 3:00
Um,
or is that via Zoom?
hang on a second. We had a kid, but we'd like him in person.
Understood. Thank you.
Thank you.
I gotta find the bus schedule. I'm a
All
Miss
right,
Apple,
well,
I gotta find a way to get there. I
comes
don't
right
have a way.
past. Well, we can provide transportation if you have a problem. I don't think you want us to do that.
Huh?
Nothing.
Mr.
All
Shannon,
right.
you are
Thank
off.
you. We'll
Thank you.
see. The people of the state of Michigan versus Shannon, Levante Shannon.
Allie Zend on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, can you state your name for the record?
Labotny Shannon. Can you hear me?
Yes, I can hear you.
Okay.
All right. This was originally set, and I had indicated that Mr. Shannon needed to come in person, but I think there may have been some transportation issues, which he won't have until 4:30. At least we are informed. So I've allowed him to appear for the purposes of this hearing via Zoom.
Okay.
All right. So we go ahead. I'm sorry, Miss Apple.
No, Your Honor, I didn't apologize for interrupting, but I want to thank the court for allowing that. Mr. Shannon is currently in Detroit, so he informed me that he would not have transportation until 4:30 today. So I do appreciate the court's courtesy in that. I did have an opportunity to speak to Mr. Shannon after the previous court hearing and was able to get some additional information from him. He would admit today to the violation. He informed me that he was consuming 20 to 30 beers a day of the DOULs, which contain 0.5% ABV. And so he would admit to consuming that alcohol and understands that that is a violation of his bond, which resulted in multiple positive tests.
This statement almost defies logic. 20 to 30 non-alcoholic beers a day? Judge Simpson instantly calls it out. His response is both mathematical and surgical, explaining elimination rates, alcohol absorption, and why the story doesn't add up. This is where legal reasoning meets scientific precision. It's a brilliant teaching moment, a judge dismantling bad logic in real time. Shannon's attorney tries to contain the damage, but the number alone, 30 beers, becomes a symbol of excess and denial. Even if each beer has 0.5% ABV, that's roughly the equivalent of drinking 1 or 2 regular beers every few hours. The math exposes the truth. He wasn't confused. He was reckless. And Simpson knows it.
At this time.
Okay, I get that. Let me just say this, because it is about a 10 to 12 can ratio of the non-alcoholic to the alcoholic beer. Problem with that whole analysis is, while he may have been consuming that amount, and I'm not going to go into great detail on this, because of the elimination rate of a human being, for him to get to that level, he would have had to consume those 10 to 12 in the time it would have taken to do 1 beer. Yeah, I don't think that happened. That's a lot. But I'll accept the admission to the violation. While I still don't believe what he's indicating in terms of how that happened, but I'll accept the admission to the violation. Did we set a new date on this yet? No. What I will do is Ms. Apple, what were the parties intending on doing with this case?
Your Honor, I was seeking an adjournment to get some documentation of treatment that Mr. Shannon completed in discussion of potential resolution or waiving this matter to circuit court.
Well, Mr. Shannon, anything you want to do before I sentence you on the violation?
No, sir. Just that if I get sentenced to some time, I would turn myself in Monday or Sunday night to the county jail.
Well, I'm going to order that the defendant, before I sentence him on the violation, the defendant you're to surrender to the Washtenaw County Jail by 6 p.m. this evening. Or a bench warrant will issue for your arrest with no bond.
Okay. Would it be okay with you if I did it Sunday night though? Because I just got one
No,
thing
sir. No, Mr. Shannon, I don't have a
very-
problem giving people some leeway.
And that's what I'm asking for. I got something really important I got to do tomorrow. And I
Mr.
can
Shannon,
tell you-
I'm going to advise you to let the judge finish his direction.
I don't mind, and I'll just say this, Mr. Shannon. I told you that I get people that they slip up. I get that things happen. And I'll be able to deal with people when that does. But what I don't like is when something happens and people are lying to me. I think you were lying to me when you were first here. I think that then through your counsel, but I mean, I understand she's advocating for you. I don't think you're telling the whole truth in terms of your consumption of alcohol. You could not put 20 to 30 beers in the time it takes for one beer to get into your system because your body can't hold it. And then you're going to be eliminating that alcohol that you're putting in. It doesn't make any sense.
Mr. Simpson.
You can shake your head all you want. You're lying to me. You're shading the truth. 6 p.m. today. Do you understand me? I'm done talking to you. Or a bench warrant will issue without bond. Miss Apple, would you like me to then set this for next week or 2 weeks out?
Your Honor, if it could be set for next week, please. Thank you.
Next week, I'll set probable cause conference September 21st, 2023, 9 a.m. Thank you.
The final blow lands. Judge Simpson delivers what might be one of the most composed takedowns you'll ever see in court. His tone is calm but cutting. You're lying to me. It's the ultimate loss of credibility for Shannon. When a judge calls you dishonest, no amount of legal maneuvering can save you. Simpson orders him to surrender by 6 p.m., ending all debate. Shannon's request for Sunday night just proves he still doesn't get it. This case wasn't about the beer. It was about trust, respect, and truthfulness under the court's eye. And Shannon failed on all three. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.